have you seen the president on the news or on the front page lately? It cannot be easy being Cyril Ramaphosa right now. The lawfare between South Africa's public protector and the president threatens to weaken one of these two important institutions of our democracy. The public protector wants the president to discipline his minister, Minister Gordhan. The president says not right now. But more worryingly, even if the president is granted the declaratory order he seeks from the High Court on Thursday, his presidency is roiled up in moral questions at the intersection of money and power. I am Karabole Tata. You're watching Political Capital. My guests today are Dr. Ivor Sarakinsky from the Wits School of Governance, who joins me from Highlands North in Johannesburg, as well as Mfesane Ka-Siboto, an advocate of the High Court, who will join me from Sandton. But before we get into the legal and political implications of this political quagmire, let's take a look how the spat between the president and the public protector has played out last week.
This letter must serve to remove any such alleged ambiguity, and given that the timeframes originally determined have now already expired, to demand such implementation as a matter of urgency and preferably by no later than Friday, 12 July 2019. Where there was no deadline now to discipline, we must do so by the 12th of July 2019. And when we say, but that's impermissible because you're now varying your remedial action, you have no such power, this is functus officio. She now says, well, I'm not varying, but she does. It's so plain language.
Because if the Constitutional Court could order President Jacob Zuma to reprimand his ministers, what is so special about this president that he cannot reprimand his ministers?
They're essentially asking that the sentence be imposed while the conviction is on appeal. They're asking Minister Gordhan to be subject to discipline, to take his medicine, when we still don't yet know what it is that he will be found to have done wrong by the review court. So it is simply impossible and inappropriate for this court to do anything other than follow the precedent that has been set and grant the relief sought by the president here.
The Constitutional Court in the EFF case said because the president had failed to honor those constitutional duties, that president had breached his oath of office and his constitutional duties. This president does the exact same thing and does not comply with his constitutional duty to assist the public protector, does not comply with his constitutional duty to ensure her dignity, but goes out of his way to associate himself with insults that she is corrupt, she's part of state capture, she's all sorts of things that Minister Gordhan says she is.
The loyalty of the president is to the Constitution and not to his colleagues in the National Cabinet. The consequences must be that her leadership would assess the prayers the president wants from the court in the light of whether or not he has upheld, defended, or protected the Constitution.
Because there is no deadline on the remedial action in this report, when Minister Gordhan launched his review, there was no need to launch an interdict. So he launched a standalone review application.
What the court will be doing by granting a stay is to preserve the executive discretion conferred by the Constitution on the president to decide when the remedial action, this disciplinary action shall be taken and what form it shall take. It is not with respect to take away the powers of the public protector. It is to subject the public protector's exercise of powers to the scrutiny of the court, which the EFF judgment says, and Justice Mkhwebane said, is the proper way to do it. She has told us in no uncertain terms that to be excused from compliance, we must get a court order, which is what we're here for. There is no alternative remedy, so any argument there really misses the complete point.
There is a clear obligation on the president to promote the unity of the republic and to promote the unity of different arms of government. In this case, the president has decided to take the stance and support the interest of one of the arms of government against the other. and therefore he has failed to live up to that constitutional promise that he must promote the unity. It is fairly easy in this case to promote unity of the different arms of government by doing what he had to do. And we'll get to the facts, my lady, to show that in this case, the President has failed to hearken to this paragraph 6 of the provisions of Section 83 of the Constitution.
We are all equal before the law, and that the rule of law requires that until the review is finally determined, the President takes no steps that may prove to end up being unlawful or irrational or unnecessary. So the very simple principle here, if we were to borrow from criminal law, is that you don't impose the sentence when someone is appealing the conviction. To think about it in medical terms, you don't start taking prescribed medication until your diagnosis is certain.
We would submit that there are two obvious ways in which the President would comply with his constitutional obligations, having regard to that part of the Public Protector's report requiring him to take note of the findings of fact. The first is to accept those facts and implement the remedial action. That will be consistent with his duty to protect and assist the office of the Public Protector. That's the first and obvious option open to the President in the light of that part of the Public Protector's remedial action. The second option is to reject those findings of fact and go to court by way of a review to challenge those facts insofar as the conclusions and the remedial actions flowing from them are concerned. Those are the two constitutional options open to the President. We can't see the third.
Will it be another judgment against the Public Protector, or could the President be in trouble? And if he is, isn't South Africa in trouble? Mfesane Ka-Siboto is an advocate of the High Court, and Dr. Ivor Sarakinsky is with the Wits School of Governance, and they join me now. Dr. Ivor, let me start with you. It's very difficult to understand countries in general, but specifically it's better when you know where the country is. I have made this confession before. I am not quite sure which part of the cycle South Africa is in. Is this the culmination, or is this the beginning? Please help me out.
Let's hope it's the culmination, but we're definitely at a crossroads as a country. The country's on a knife edge in a sense, because there are a whole range of tensions and conflicts that are coming together. And the big test is whether our new democracy and our constitutional system can survive the crises that we're in, and whether the rule of law and basic procedure will prevail once these crises play themselves out. So it's a very testing time for South Africa as a nation.
Mfesane Ka-Siboto, your kind must be smiling from ear to ear. Lawyers are kept busy, and by definition, so are our courts. Is the political ground in South Africa going to be fought using a weaponized instrument like law?
No, absolutely. I mean, there's no doubt about it. We've already seen quite a lot of litigation around the Public Protector's Office reports. It's not something that's going to end now. We're only at the start of it. I mean, either than the Public Protector's reports, there are other legal processes that are being undertaken personally by politicians, not necessarily related to the reports of the Public Protector. So I agree with your introduction. We're in a very interesting time politically, and certainly there's lots of litigation coming up.
Professor Sarakinsky, here is the basis of it all. Is Cyril Ramaphosa right to wait for the review of Pravin Gordhan's application with regards to the Public Protector's findings, or is he protecting his friend, as the opposition was saying?
At a political level, he's probably right to do that, because the whole event and the whole complaint appears to be politically motivated to weaken a very powerful ally in Cyril Ramaphosa's camp, and someone who's involved in the cleanup of corruption and state capture. And it does appear as though the complaints are an attempt to get him out the way because of his effectiveness in cleaning up. So I think he is right to appeal it. Legally, whether he'll win it or not, I don't know. But politically, it makes sense for him to object.
Mfesane Ka-Siboto, I am worried. You are the legal head in this discussion. I'm worried when the president, does not reprimand his minister, in this case, Pravin Gordhan, for the kinds of assertions he's made about the public protector. And Vincent Malega was arguing that it's the president's duty to defend and protect the dignity of the public protector's office, that it's his constitutional duty. Is he remiss for doing that? And could he have brought the warring parties, as it were, the minister and the public protector's office, sooner to his office at the Union Building to avoid this legal hassle?
I agree with you. Frankly, it's quite symbolic how the public protector's office has been attacked of late, rightly or wrongly, and not just by politicians, but by the media as well. Remember, we're talking about a Chapter 9 institution here. Whether or not you agree with the findings, that's one thing. But it's another to malign and attack the office. We're still the head of that office, because remember, the Constitution guarantees the protection of a Chapter 9 institution given the role that it plays in our constitutional democracy. So I agree with you that the president should have acted sooner, but one can see why the president would perhaps not have taken the steps as yet, because he himself is implicated and is being asked to implement the remedial actions of the protector, and of course he's taken some of these reports to a court of law. So you can see why it would perhaps be a conflict of interest for him to call the public protector in at this volatile stage, because one might argue that, well, perhaps then he wants to influence and abuse, or rather intimidate, the public protector. So from a political point of view, you can see why he hasn't. But in the normal course, certainly something should have been done, at least from the president's office, be it the deputy president for that matter, to protect the image of the public protector from the attacks, both from the politicians and certainly from the media as well, which I think in some instances is unwarranted and excessive.
But Mfesane, I'm going to follow up there with a question and ask you, isn't the public protector also remiss in this case to, one, move the goalpost by determining a date for those remedial action to have been enacted? And that was as a matter of afterthought. It was not part of the original report. And also, isn't she expecting the president to punish a minister before he, well, actually knows if the facts that she, allays are true have been challenged? Isn't it a bit too soon?
No, because remember, the public protector's findings are binding. In other words, they are taken to be fact. So the question of whether you should test them to be true or not does not even arise. The question of whether they're true or not is if the implicated party wants to challenge them in a court of law. Then that question arises. As a matter of law, as soon as she makes the remedial actions, at that point, her actions, or rather her remedial actions, should be implemented. And coming to a question of time periods, imagine a scenario where she asks the president to do X and does not give a time frame. If the president sits on the report and doesn't act for the next 4 or 5 years, on what basis do you hold the president to account? So of course the time period is relevant in that sense.
When we return, we explore exactly that, only the political ramifications with Dr. Sarakinsky. Welcome back to Political Capital, where money meets power. In a nutshell, all the problems facing South Africa's president right now, exactly that, politics and money. Still with me are my guest, Dr. Ivor Sarakinsky from the Wits School of Governance, who joins me from Highlands North in Johannesburg, as well as Mfesane Ka-Siboto, who's an advocate of the High Court, who joins me from Sandton. Dr. Sarakinsky, I start with you. Politically, how does this read for President Cyril Ramaphosa? I mean, as far as I see, a lot of his presidency hinges on the outcomes of the case of his minister. And by what we know now, that's been out in the open, despite the fact of how those leaks came into being, we know that Pravin Gordhan was very instrumental to the election of Cyril Ramaphosa as president of the party and subsequently of the state. Is Cyril Ramaphosa's future as president hinging on Pravin Gordhan's success?
I don't think his future as president hinges on this matter. But what this matter does clearly show is that there are a number of controversies whirling around Cyril Ramaphosa's presidency, and the New Dawn isn't as clean as the New Dawn was supposed to be. Whether the allegations are true or half true or false, there's a serious scandal now in the office of the state president. And that is going to have some damage in terms of the credibility of the office of the president to drive a reform agenda in terms of revitalizing the economy, restructuring the politics to make society more effective in influencing decision-making, all the promises of the New Dawn. And all these scandals, and there are numerous of them, many of them, are undermining his ability to act and lead the country. And I think that's a real problem and a serious challenge to him as state president.
Now, I'm going to have an ensuing question on that, of course. And that question is, the president can win on Thursday. He can get a declaratory order giving him exactly what he seeks, to stay execution of those remedial actions. But morally, there will still be a lot left for the president to talk about. This is the same president who campaigned essentially on two things, on the economy and on a corruption-free ticket. Is the president falling short?
At the moment, it seems so. How short is open to debate, but he can't easily present himself as the clean-up champion that his New Dawn campaign presented him as leading. And the scandals around the donations to his election campaign for ANC leader in 2017 has left some damage to his status and credibility in the public eye. And he is weakened now as a result of that. So he's got a difficult situation to manage, and he's got to play his cards very carefully here. And in situations like this, probably the best policy is to come clean, be honest, explain and apologize where necessary. And at the moment we're seeing a battening down of the hatches and sit it out approach. And that's just going to lead to more suspicion and more outrage and more criticism.
Mfesane, this is more of your realm. Now, clearly this case could cut both ways. The president could get a favorable judgment or not. And the same for Busisiwe Mkhwebane, the country's public protector. What does another loss mean for the public protector? Can she then start accepting the fact that this was a high-stakes game, especially when, you go up against the office of the presidency? Surely she must expect some sort of repercussion, especially if she's not favored by Thursday's judgment, right?
Correct. Yes and no. Politically, yes, that's the obvious answer. Because what has been shared a lot, and certainly has been pushed by the media, is that, well, the public protector must be so incompetent because it would appear every time she goes to court, she loses, and most of her reports are going to court and she loses. Well, as a matter of fact, statistically, that's not the case. Because remember, the public protector does not just report or she doesn't just investigate high-profile matters. I understand that she's released reports in excess of 200, only 5 of which or thereabout have been taken to court, and she's lost a couple of the 5. So in terms of percentages, that is factually incorrect. And remember, the public protector is not there to investigate high-profile matters. What do we make of the other equally important reports that she releases on a weekly basis, monthly basis, that affect the poor and the vulnerable, the protection she's afforded to the public in her other reports? So that has to be taken into account. Of course, it's easy for the media to sensationalize and focus on the high-profile ones, and which, in my view, is unfair. And dealing with the question of particularly this matter, I don't think that should be basis for the public protector to now target tail in between her legs. She's got a job to do. Of course, she will make incorrect findings every once in a while, whether that's deliberate, whether it's political, whether she's part of the pro-state capture agenda. I have no opinion. But the fact of the matter is she remains the public protector and she must do her job. And what must happen is that she must be protected. To the extent that she's found to be acting in bad faith and so on, well, it's for the court to pronounce and she must suffer the consequences of that. But it can't simply be because she seems to be reporting and finding against a particular faction politically, then she must be chastised. That we must guard against.
Mfesane, courts have pronounced to that effect. They found her to be they haven't found her to be a neutral and unbiased body with regards to her investigations. They have chastised some of her work, all of its shortcomings. And when you speak about her being the public protector for all, one has to balance that with the fact that she did not even bother speaking to some of the victims of the Estina dairy farm scandal. Now, when you consider the quantum of the negative aspects that the public protector has received, as you say, by the media. By the way, the media is not one monotonous thing. We all have different ideas, but it has been publicized. And two, also by courts of law. Do you have trust in her ability to conduct these investigations? Do you believe that the email that she alleges in the Bosasa case, for instance, was acquired lawfully? Is she the kind of person you would consider a neutral party?
I think that's a fair question, and I accept the point you make. All I seek to put across is this, that the question of the fitness of the public protector should not be a political debate. Fair and well, the political debate can be held. But to an extent, we question her legal aptitude, her legal ability. That is for the courts of law to pronounce on. And you correctly say, for example, the Constitutional Court found very scathingly against her, and I accept that as well. But from a legal point of view, there's nothing really strange about that, because this happens in the ordinary course in the courts of law, where you find courts of appeal being equally scathing to their own colleagues who are in the lower courts. Now, we don't find a debate as to whether those judges are fit and proper to sit on the bench, simply because these aren't high-profile matters. So I tend to empathize a bit with the public protector from that perspective, that there's nothing strange from a legal point of view when a higher court has something very unfavorable to say about a decision, either in the lower courts of the public protector. To an extent, of course, she lied. And if we accept that she lied, and she has to face those consequences, but legal processes must follow. It can't just be purely a political debate.
Dr. Ivor, I close off with you. She has investigated. She has given many remedial findings. But if this particular, case on Thursday versus the president, and I guess by extension, the case against Praveen Gordhan, do not go the way of the public protector, is this quits for her? Is this time? Should she hang up her legal robe, as it were?
I'm very sympathetic to the point made by my fellow panelist on this one, that just because she loses cases doesn't mean that she's got to be removed. And if she is to be removed from office, there is a procedure in the Constitution for that, and that must be followed through in Parliament, and it's a 2/3 majority vote. And that's a separate issue from appealing and reviewing her findings through the courts, as has been discussed. So whether it's the end of her as public protector, I'm not so sure. I think that it's a long road for anyone who wants to get her out of office to do so through the proper process. It's not going to be a lynch mob. It's not going to be screaming and shouting. It's going to be a parliamentary majority of 2/3. And if one looks at the numbers, it's not going to be easy for any grouping to get 2/3 in Parliament. But the legal issues are the most important ones in terms of establishing a culture of procedure and rule of law in South Africa, where citizens see the law as reflecting of their values and accept the law and abide by the law. I think this is the real issue. And if everything can be appealed and if everything can be struck down, it means that you hang in and you fight another day and you try and win it at another level and you just delay decision making. And I think that's a real worry because it undermines the power of the rule of law to regulate society.
To both my guest, Dr. Ivor Sarakinsky from Wits School of Governance, as well as Mfesane Ka-Siboto, an advocate of the High Court, I thank you both for joining me, and I thank you at home for joining the show. We'll be back on your screen next Tuesday at 6:30 Central African Time. Until then, keep it locked right here on CNBC Africa.